Oh, I'm not the host. I'm not the host. Let me get out.
All right, so welcome to our employment webinar. We have two great attorneys, Peter Lowe and Daniel Stockford from Brann and Isaacson, who are joining us today. And we know that this webinar is being recorded, so we'll try to make sure that this gets out there to others who might not be able to join in person. But we are recognizing that a lot has changed, both with the Families First Response Act and the CARES Act. And it's changing the way those of us in business are thinking about our staffing and our operations, and I think trying to navigate a whole bunch of new rules and regulations as they come out as it relates to employment and the way we manage our businesses. So without further ado, I want to welcome both Peter and Dan to the conversation today, and I will hush up. In terms of just some basic kind of technical components, if you have questions, you're welcome to type them into the chat function. I know Peter and Dan will solicit them as we go. And so I'll try to manage mute in case we have any background noise, but please do unmute yourself. You have that capability. to ask any questions that you might have. And Peter and Dan, this can be as interactive as you would want it to be. With that, thank you for your time, gentlemen. I'll yield the floor.
Oh, thank you so much. Yes, feel free to pose questions. Good I guess it's afternoon, isn't it? Yeah, I'm having difficulties establishing both the time of day, the day of the week, whether it's a weekend or not. It all seems to blur and blend. And when we go back and say, well, this particular law was passed, again, it seems like everything's happened on warp speed. So forgive me if I say last week when it was the week before. What we'll do for today's webinar is Dan and I are going to go back and forth, and I'll pose questions, and Dan's going to provide all the answers as he always does, and I'll chime in as well. But we thought what's really best for people to educate them, inform them right now is to hear the types of questions that we are fielding. So Dan and I, and we've got Hannah Wergroff from our office as well, who's assisting us, and others, work with employers across the state and beyond, small and large, and we'll share with you the sort of the cross section of questions. It's nonprofits, it's school departments, it's municipalities, it's business, and there's an endless variety of questions that we're hearing and receiving over the past several weeks, and they're beginning to shift, and we'll talk about that a little bit as well. But rather than walk people through the fundamentals of these two large pieces of federal legislation, we're going to assume for the listener a basic degree of knowledge. We're not going to say, all right, here are the fundamentals of the First Families Act, or we'll call it FICRA for ease, because there's an awful lot out there already. And if you need those details, there are many, many resources, including Brann and Isaacson's website. We have a COVID-19 resource library right on our launch page there. And we've been putting out a lot of information, a lot of client and business alerts. So the details can be found in many of those documents. But I know people want practical advice, they want guidance at times like this. So we're gonna go through in that manner, and if questions come up, and other folks, any of you have things you want us to address, we'll certainly do our best in the time. When we started giving advice in this area, the initial questions were, we've got somebody who lives with a family member who is ill, perhaps has symptoms, perhaps even has been tested and has the diagnosis. What should we do? What do we need to do? While those questions are still important, they have greatly diminished. And that's a reflection, I think, of two factors. One of which, unfortunately, is so many of the people we work with out there have had to substantially curtail or even cease operation. So you don't get those questions when people don't have anybody coming to work. But secondly, I think our employers have had the resources, got the answers, and they figured out what they can do. And as this went from being a significant epidemic health issue to a pandemic, the legal guidance coming from lawyers and frankly from the federal government and the state government was, you can ask more and more and more, you can require more and more and more. So the safety issue has only become more prominent. So rather than focus on the questions about what can we do to put somebody out, how long can they stay out, and we're glad to address those if people have those questions, but we'll focus perhaps a little bit optimistically, but I know it will happen, is when people start coming back to work. And particularly when we have employers who maybe have furloughed all of their employees or some of their employees, what would we expect? What do we predict when it's back to business? I'm not going to say it's business as usual, and I'm not going to make any predictions about timing. That would not be within my expertise or purview. But I am optimistic enough that the time will come and we'll be giving that advice. So Dan, let's tee this up a little bit. I'm a restaurant. I closed entirely. Required to close. Maybe I had a little skeleton crew helping with curbside, but largely we laid everybody off, or we put them out on furlough. Good news is we're going to be opening again, and I've got some questions of what I can ask of those employees. Can I ask those employees who've been on furlough to provide me with medical information? Can I ask them, have they had symptoms? Can I ask them whether in fact they've been tested for COVID-19? Can I ask them about antibodies? Can I go down that road? And what are some of the risks if I go down that road when we're looking at bringing some people back to work?
So the legal provisions that we need to be concerned about in evaluating what can be asked are under the Americans with Disabilities Act. And the EEOC has issued some supplemental guidance that addresses the ability to make medical inquiries in light of the pandemic. The bottom line is that the EEOC recognizes that COVID-19 does present a direct threat or potential direct threat to others in the workplace. And it is well established that an employer can ask questions that are designed to ensure that to determine whether there is in fact a direct threat that arises from an employee being in the workplace, and questions designed to make sure that there isn't a direct threat. So it is permissible, or it will be permissible, when employees are being recalled to work to make those inquiries. And my general advice would be to avoid asking about the specifics of the employee's medical condition, but to ask questions that are geared toward determining whether in fact they are safe to return, whether they may pose a risk of infection to others. And I think those types of questions could be broad enough to include, are you showing symptoms? Do you, have you had it? Have you been tested positive for it? When was that? So those are, I believe that those types of questions are fair game in order to ensure a safe workplace.
Sure. Yeah, and I'd add to that, I believe that the current climate and the guidance we're receiving is that if employers decide that upon the return of an individual, or in fact a larger group, that an examination or a procedure such as taking the temperature of each employee as they return, the day they return, the next day, the day after, that would now be regarded as permissible. In other times, that would be a clear no-no under, as Dan said, the Americans with Disabilities Act, but the EEOC has said that that's acceptable and appropriate in this time. So I'm not ever given to give medical advice. We rely on the experts. So I'm not saying that that's necessarily medically appropriate or not, but it certainly could be a tool in the toolkit for employers, because what you're going to face when you bring people back is what we see, we get a lot of questions about this right now is the fear, the understandable fear. And, you know, there'll be a fear of, is it truly safe to return to work? And we'll be faced with getting questions and giving advice about, so what happens if an employee says they're not coming back? They're not ready to come back, they don't feel safe to come back. And we've been fielding those questions a lot. Those have somewhat diminished as well. And just so everybody hears the advice that we've been given, you know, obviously if someone says they don't want to come to work right now, they're unwilling to come to work or they're fearful to come to work, like any other issue, we're encouraging the supervisor, whoever, HR, have a dialogue with that person, understand what it is that's causing them that fear. Sometimes it may be a greater vulnerability that that person has than the general population. And if that's the case, it might become a medical disability accommodation issue. If you exhaust all of those issues and the person simply has a fear of coming to work, then, you know, in the absence of some paid leave program or benefit, that person may in fact be out on an unpaid leave of absence. There are different safety nets, of course, which we can get into. The real challenge, and I haven't faced it yet with a client, but you know, I know clients are concerned about it, is if they get a critical mass of employees who say, sorry, I can't come into work. And if they are deemed either by the state, by the governor's orders, or by the new legislation to be essential workers, then there can be, you know, a significant issue. Dan, let's talk about our new favorite law, the first families, or we'll call it FICRA. And we've spent an unbelievable amount of time in the last couple of weeks from when the law passed to these guidances that came out drip by drip from Department of Labor, and Hannah, who's with us here today, has been a great resource to analyze those and put out information on those. And then to the Department of Labor's credit, regulations were issued on April 1st, and that was the date the new law came into effect. And, you know, I don't think of another situation where the regulations come out the day the law comes into effect. There were, correct me if I'm wrong, I think there were 124 pages. And I remember they came out and we had a little bit of a division of spoils that night. And Dan got the task of reading the first 80 pages. And we, you know, I think Dan and Hannah might have worked late and early through the night to get more information out on those, because there were so many questions we were getting about this new law, and we were deciphering what was in the regulations to give further guidance. So, Dan, well, let's start with a question that seems to be on a lot of people's minds. We're hearing from our clients. Okay, this new law is in effect. Some parts of it are very, very complicated in 124-page rule. What happens if I don't get it right? What happens if I make mistakes? And is there sort of a period where I'm immune from any liability enforcement? Is there a safe harbor for me? Because this stuff is hard and complicated, and I'm trying to figure out the CARES Act at the same time as figuring out this new law. Dan, can you promise me a nice reassurance that I should be able to sleep at night and not worry about this?
Well, the U.S. Department of Labor has tried to provide some reassurance to employers on that by saying that they won't initiate any enforcement actions based on good faith attempts to comply with the law until April 17th. I noticed that it is now April 8th, so that doesn't give a whole lot of reassurance. And they also qualify that by saying that they reserved the right to go back and retroactively reinforce it to April 1st if an employer, doesn't take good faith steps rather, to address any non-compliance that might have occurred during the first few weeks that the law is in effect. So there is some relief and reassurance there, but the bottom line is that by the 17th, the general expectation is that employees will be in compliance.
So it seems as if the Department of Labor on the 17th could come knocking at your door. Now, the chances of that are exceptionally remote, it seems. But if they're triggered by a complaint that you're an employer who has simply said, we can't afford this, or this is too complicated, or we're too important, if they get a complaint of that nature, then although their resources may be stretched very thin, then they may come a knocking. I mean, I really don't expect that they're going to be in any audit position for a long time. It will be more reactive to complaints and issues and concerns, and those can all start on the 17th. What I'm telling our clients is don't ever believe that you can achieve perfection right now. What laudable goal, but somewhat simplistic. I say don't wake up at night over the First Families Act if you can possibly avoid it. And simplistic, but engage in good faith. That's what the Department of Labor is saying. So yes, there may be some things that are confusing. There may be some things you get wrong. And if they're pointed out and they're established to be wrong, your best advice is then to correct it, to seek to correct it. And I think you'll be in a lot better position. So trying to provide, we try to provide the answers. Sometimes we have to say to people, it's still not clear. Use your best judgment, use your good faith, and that'll be the best place to rely upon. And I think I said it in previous webinars, in some of these close call issues, there's nothing, I think, more important than putting the safety of your workplace, the safety of your customers, the safety of your employees first and foremost, and that may drive some of your decisions. So,
Peter,
yeah.
Can I ask a question that came in privately that I think touches on that? And I've got a couple that I'll pepper in as you go along if I'm hitting in the right spots. But what about essential employees who are supposed to go to work but don't feel safe? So what accommodations does an employee have to offer about social distancing practices, about safety in the workplace, and what role does either unemployment insurance, the kind of extension of the Family Medical Leave Act, or the Family First Response Care Act, where does it fall?
Lots of layers to that question. So
yeah.
At the highest level, and then Dan, you chime in too, but at the very highest level, so if I'm working for an essential business, and just a couple of different nuances there. I may be deemed essential by the governor, but I also, for example, may, under the First Families Act, be deemed, by way of example, a healthcare provider. And I think we'd all agree that healthcare providers are essential in this environment. I'm not sure we'd all agree that lawyers are, but under the governor's order, we are deemed essential. We're riding that wave right now. No one's ever said that to us before. But in any event, if you're considered essential, and let's take a healthcare provider, then it's back to my kind of analysis before. It's finding out the reason that person doesn't want to come in, and if stripped down to its barest, it's not a basis. It's not that they've been put into quarantine. It's not that they got symptoms. It's not that they've tested positive. It's not they're caring for a family member. It's not that they're subject to a statewide, quarantine order. So if it doesn't fit with any of those criteria, the employer is certainly within its rights to expect that person to come to work. That's the bottom line. Are employers in this climate truly going to say, well, if you don't come, I'm going to discipline you or fire you? I haven't been even asked that question yet. But and I think many employers very understandably would tread in a very, very cautious manner. I think that those, the difficulty with what you describe in that situation where none of these eligibility apply, it's not clear to me that whether that person would be eligible for unemployment or not. But employers know this, they've heard us say this before, it's not the employer's job to tell people whether or not they'll get unemployment. It's not within your control. That person who won't or can't or is too fearful to come into work but doesn't have the safety net of any paid time off, first families, anything else, expanded FMLA, then they may seek unemployment. And obviously that system is under enormous stress right now, and unemployment will determine whether in fact there's good cause for them not to come to work, which would then potentially provide those benefits.
Does that same employee in that scenario have a right to ask for any accommodations in the workplace? So well, you can think about like a grocery store employee saying, I won't come in unless you put up the plexiglass.
Yeah, so every business has to observe what are the requirements of the governor's orders. Those are laid out, and they address retail in particular, or public-facing environments. So every employer should be carefully, and I believe they are, reviewing those requirements and ensuring they have them in place. Every employer should be looking, even for an essential business, to determine whether or not that person can do their job remotely by teleworking, because that still is the first preference or the first requirement. But as we know, there are just some jobs that require you to be in Whole Foods and serve customers, and it's incumbent on the business, of course, to put in place all of those social distancing and other requirements. And plainly, if somebody makes a complaint that you're not doing that, that employee potentially becomes a whistleblower, and employees are going to have to be judicious and careful about that. Whether or not they believe that person is correct or not, that's going to be, I think it's almost certain that we will see whistleblower issues and whistleblower complaints come out of this down the channel. I've got a question for Dan on an issue that I think when we've done webinars before, we have not been able to really give too much of a helpful answer, but I think we can now. So I'm a small business, I'm under 50, and I heard that if this is going to create a hardship for me, I can get an exemption from this first families law. Is that true? And how do I go about it? And how broad is that exemption? And is that, Dan, something that the new rule gave us a bit more help on?
Yes, we did get some much needed clarification on what the small business exemption means and when it applies. First, we should make clear that it only applies to benefits that are available under the Families First Act that involve the employee being unable to work because they are caring for a child whose school or daycare is unavailable. So the exemption doesn't apply to other types of leave that are available under the paid sick leave provisions, the 2 weeks of paid sick leave provisions, for other reasons. So for example, if an employee is unavailable to work because of a quarantine or isolation order, or they are unavailable because they're actively seeking a diagnosis, those types of reasons that might entitle them to paid sick leave, the small business exemption doesn't apply. It's limited to either paid sick leave or expanded FMLA benefits for employees who are caring for a child whose school or daycare is closed. Second, we've received clarification that the exemption doesn't need to be applied across the board to all employees. So it allows an employer to make an individualized assessment of whether, in a particular case, extending the leave benefit to employees would jeopardize the viability of the operation as a going concern. And there isn't an application process. The guidance indicates that employers should develop, if they plan to take advantage of the exemption, they should develop and retain documentation that an authorized official of the business has determined, and there's 3 different criteria that would allow application of the exemption. The first is granting the leave would result in the business's financial obligations exceeding available revenues and cause the business to cease operations. Second, the exemption could be available if absence of employees from work would entail a substantial risk to the financial health and operational capabilities of the business, because the employee in question or the employees in question have specialized skills, knowledge, or responsibilities. And then the final criteria would be if there aren't sufficient workers who are able, willing, and qualified to perform the labor or services that that the employees provide. So what we would recommend if a business is planning to take advantage of the exemption, that there be some kind of internal documentation that documents the rationale for application of the exemption under those specific criteria. So for example, that could be an internal memo, between senior officials, a memo between board members. In any event, it would be prudent to develop that documentation and keep it. But the Department of Labor has also made very clear that they don't want to see it unless they come back later for an audit. They don't want it sent to them.
Don't make, they basically have said, don't mail us anything. Don't send us anything. We don't want it. We don't want to see it. So it's sort of a self-declaration issue. And we've had less questions than I thought recently about that exemption. And I think when people figured out it was not as broad, it didn't simply say the law doesn't apply to you. It's narrow, as Dan said. Then there's been less exploration of that. Maybe people are just out there self-declaring it and we don't know about it. Another issue that we've had a lot of discussions about is, and I keep this very high level because it will impact just certain people, certain businesses out there, but critical ones, is what is a healthcare provider? And the regulations indicate that anybody who works in, for example, a doctor's office, anybody who works in the doctor's office would be considered under the healthcare provider exemption. And then the rule goes on to list a bunch of similar types of facilities. If anyone's weighing that and considering that, there are some nuances to that, and I would say get legal advice about the nature of the healthcare provider and how expansive it is. Like other legal issues, there are some questions that are a little vague right now and unanswered, but we've dealt with a number of people and have been giving advice about what is and what's not a healthcare provider. Another issue, just to put it out there, I think you all know there's a poster that's required. Remember, this is for employers with less than 500 employees. I think we all know that by now. Our view is that whether or not you have an exemption, whether or not you're a healthcare provider, so you can say none of our employees are eligible, we're telling people, put up the poster. Everybody put up the poster. I realize that that's a little tricky sometimes because you put a poster up in your workplace saying, hey, this is the poster. you may get these leaves, and in fact, if you're a healthcare provider, no, you don't. And we've said you shouldn't alter the poster in any way, absolutely not. But maybe you want to put some other information up on that bulletin board. We learned just the other day that you can't put, all of us have these crazy walls of posters that, I doubt many of our employees ever read, but you can't put a binder up there with all of them in the binder and pin the binder to the wall. They've all got to be displayed. So we've been getting questions as arcane as, very complex leave issues to where do I put the posters? And by the way, if all your employees are working or either working remotely or not working right now because of a furlough, then you may want to think about emailing those posters or putting them on a company intranet or a place where employees would see them. On the poster, back to the poster for a second, one of the reasons, reason number one, so all of you out there who are in HR, you'll start understanding reason 1 or 5 or 6, but number one is if a person, an employee, is unable to work, including telework, because they're subject to a federal, state, or local quarantine or isolation order. They're subject to an order. That term we debated about how broadly to interpret it, and the recent rule makes it quite clear that that is quite expansive. And just a pointer to people, and I think the best thing they can do is look at all of the question and answer information. It's dealt with in detail in one of our alerts. There's a statement in the rule that says if somebody is following, I'm paraphrasing here, but an advisory from the state or federal or local government, that could constitute a quarantine order as well. So sometimes you'll have to understand what is the advice that has been given out that then pertains to the employee to see if that number one applies. That's a little bit of a tricky issue. Tread carefully with it. And what makes it tricky is there's a state level of order, but then there's individual municipal orders. Portland has a different one to South Portland. Bangor has a different one. I don't know if Brewer has one yet, but it might potentially might. So you've got to definitely tread carefully in that regard. All right. We can certainly tackle other questions if they come up about first families. There are lots of them, and but I certainly encourage Hannah and Dan put together this. I believe it was April 2nd, very detailed Q&A, and I think that for anybody who has the devil in the details questions, there's a lot of good information in there. So rather than us repeat it all, I steer you that way. So one of the things that we plainly have been giving a lot of advice and we get a lot of questions about is I can't afford my payroll any longer. And not only can't I afford it, but there isn't work, or there's not enough work for people to do. And I frequently get this question, and this is at a high level. Is a layoff the same as a furlough? And what is a furlough? Can you explain to me what a furlough is? Because furloughs, this term, I think we've dusted off. You hadn't heard it for a long time, but everything now is about furloughs. Dan, do you want to just talk about what you would consider, we consider to be a furlough, and is that different from terminating or laying somebody off from employment?
Right. I mean, generally a furlough would be considered a temporary cessation of work offered to the employee with the expectation and understanding that once work is available again, that the employee will be returning to work. Whereas a layoff generally is considered more permanent. For purposes of the Families First Act, there really isn't a difference as far as whether an employee will be potentially eligible for the benefits. Because if the employer is not offering any work to an employee, either because they've been put out on temporary furlough or because they've put out on a longer term layoff, the reality is that if no work is being offered, then no leave is available or necessary. And in that case, the employee's potential benefits would be through the unemployment process.
Yeah, so that's an important distinction. And we had some people, as when the law was approaching, asking questions about, what are the differences between terminating somebody and laying them off. And just so we're all clear, well, plainly, if you terminate the employment's over. They'd have to be rehired. There's no expectation of returning. There's no eligibility. But as Dan just said, if the person is on furlough, the same would apply. There's no eligibility because there's no work available. Sort of a related question is, all right, we have somebody who is currently on a leave and they're getting the emergency paid sick leave, which is up to 80 hours, 10 days. And they met one of the 5 reasons on my poster. And they're receiving that, and we're going to get the tax credits for that. But now our business is in so much trouble. I need to do a new furlough. And that person who is currently out on a leave, how does that impact them? A lot of us are used to in the legal world, you're on a leave, you're protected. We use that term quite often. Does that mean that that person has a right to come back to work, that I wouldn't be able to furlough them because they're on a leave? Would that be perceived as retaliation if they're on my list? Should I pick somebody else? You want to tackle that one, Dan?
I mean, it really highlights an area where we see a lot of potential for claims that could result from this whole thing. There's a possibility that employees who are put out on temporary or permanent layoff while they're eligible for benefits could claim that they're being retaliated against for taking advantage of the benefits. And both for purposes of making decisions about reductions, as well as making decisions about who you bring back once we're in people are in a position to bring employees back to work. It's important to think about those reasons and to document the reasons in a way that you'll be in a good position to demonstrate that if somebody does file a claim that either it was, either the decision to terminate somebody or not bring them back was motivated by their eligibility for leave benefits or by some other, for some other protected class reasons such as age, it will be important to be able to demonstrate that the true reason was a legitimate and non-discriminatory reason.
Yeah.
Now, obviously, everybody's dealing with financial challenges associated with this whole thing. So in most cases, the decision, whether to bring somebody back or to end their employment is going to be motivated at core by economic considerations. But you'll want to be able to demonstrate that the reason that you picked particular individuals to be laid off and kept others wasn't based on some kind of protected status.
Yeah. And just to echo that, so, you don't want to treat anybody who's been on leave or is exercising leave any differently than anybody else. That doesn't mean that their leave guarantees that they come back. Or, so if in fact you say we have to unfortunately lay off another 20 people and you use some consistent criteria for that, then that person, in fact, may find that their leave ends prematurely because there's no longer work available for them. So that I think is very likely to happen. A couple of other items, and we'll get to unemployment in a second, because there's a ton of questions that certainly employees are understandably having, as our employers. And we want to talk about that for a few minutes. But first, just a couple of other items, OSHA and workers' comp. So is this, if in fact you have an employee who tests positive for COVID-19, what we're advising clients is, if there's an indication that the person became infected at work or through work, then we're advising make a report to OSHA of that incident. The OSHA rules say that diagnosis should be confirmed by a healthcare official, and there's some other criteria, but I'd advise in those instances that you go ahead and make a report. If you have an employee who tests positive, but it's not through any relationship to the workplace, then you have no obligation, just to be clear. And then the second issue is workers' comp. Somewhat of a similar exercise. Plainly, the only is potentially workers' comp coverage if the person became infected through work, and specifically through the type of job that they're performing. I would again advise employers err on the side of caution and file that report of injury if you have any question, and then it will be in the hands of your workers' comp insurer, and they certainly will be approaching these issues on unfortunately a regular basis, and dealing with it in a consistent manner. And a little bit like unemployment, eligibility for workers' comp doesn't rest ultimately in your hands as employers. It's going to be dealt with by your insurer, and if there's a dispute about that, then the workers' comp board. And we haven't been getting, to be honest, we haven't been getting a lot of questions about either one of those that come up from time to time.
Can I do a follow-up on that, which is something that we're hearing from a couple of employers as well as employees, is somebody either hears that they might have been in contact with somebody, which is pretty rare at this point, who's tested positive, and that's a reflection of our testing rates, right? Or what's more likely is they call their primary care doctor, they describe their symptoms, say that they have a fever, and because they're not over 60, or because they haven't been in direct contact with somebody who has had a test that was positive, are directed to stay at home and self-quarantine, and are not offered the opportunity for a test. And so in those circumstances, we heard from the hospitals pretty quickly once this started. I mean, within the first week and a half, that they were being overwhelmed with requests for employees to be tested and cleared to go back to work, which was not something they could do. The CDC eligibility guidelines for testing wasn't allowing that. Their testing capacity didn't allow that. And so for employers who are hearing an employee say, I called my doctor, I'm showing symptoms, they told me to self-quarantine, I can't physically work even from home because I'm sick, but I haven't tested positive because I don't have access to a test. How does an employer or employee handle that?
Yeah, so I mean, in some of those situations, what you just described, the person hasn't been able to have the test, which you're right is absolutely commonplace. But in that circumstance, if they're working for an employer who's covered by the First Families Act, then they certainly, I would think, have been advised by a healthcare provider to self-quarantine. So during that period of time, back to my favorite poster, reason number 2, check that box. And they may, at that point, they should be eligible for leave benefits, provided that there's not an exemption and all those other things we talked about. But let's assume they are. That's almost, in a way, the easy part. Then the more difficult part is if employers And frankly, you can understand why an employer in this climate would say, well, that person now wants to come back. They've been self-quarantined, but what do I have to rely on that they're okay? Their word? Should I just take their word? And we're not saying that employees shouldn't be trusted, but this is a time where you bring somebody back and in fact they're infectious. It could be catastrophic on many fronts. So that's a really difficult one. What the guidance came out with, and I think this was, there's been so much guidance. I think this was EEOC, and this is one of the things we've summarized in our alerts, is that they said if you can't get that, they still advise in that instance that employers may get something from a healthcare provider. So if I've been advised to be out by my healthcare provider, and my healthcare provider has been monitoring my health, while I'm not going to have a doctor's office visit, I may well still be able to get something from my provider that says, yes, I've served myself quarantine, I'm not showing symptoms, and I'm in a position to return to work. Maybe I'm being a little bit idealistic or optimistic, but I would at least initially suggest to clients that they seek that type of documentation. And if they can't get it, then they need to have further discussion and look at other options. And I agree, and we don't want the situation where a person is perfectly well, fit and able, and they can't get back to work, and that will create issues. We have not been getting those so far. I don't know, Dan, you can speak up on this. I haven't been getting those issues where we've heard that people are being blocked from returning to work because of the paperwork criteria.
No, same here.
Do we have a few? Okay.
There's about 10 minutes left, and I want to make sure that Rachel and Jessica have a chance to ask any questions. And I have one more question that came in privately to me and that I shared with Dan to give him a little advance warning on it, in case you hadn't noticed that question yet. And I'll raise that in a minute. It's another question that we had gotten in. But Rachel and Jessica, did you have any questions? I want to make sure we give you a chance to ask any questions that you might have. Jessica says she's all set.
So Dan is getting the advanced questions, so he can sound so smart. I'm going to have to lodge a official complaint here.
I'll send it to you.
Okay. Okay.
I'll ask it out loud too if Rachel doesn't have anything.
Well, I think one thing I'll let Dan digest that question, and we'll just talk a very high level about unemployment. So one of the things that we've been getting a lot of questions about is, how does the state unemployment benefit, the maximum, I'm never good at remembering numbers, but I think it's $445 and maybe a little bit extra if you have dependents. That's the maximum weekly benefit if you're eligible. What about the unemployment funds in the CARES Act? Well, Hannah's been doing a great job of monitoring all of that with the Department of Labor. And I think the Department of Labor, and they're not alone, I'm sure other states have been like, we've got to figure it out. And last time we checked, it was, this is complex and we'll be getting information to you as soon as we can. What we've been able to glean from our research, and don't take it to the bank yet because it's not certain, but it appears that the $600 of additional funds that will at some point be available from the federal CARES Act will be in addition to the $445. One big question that we've been presented with is, what if my employee is working reduced hours and they're eligible for benefits, as I think everybody knows, so some benefits, will they also get that $600? And we're saying it appears to be the case the way the law is written. We'll see what the final position is from the Department of Labor. One of the realities is, and I think it's been out there in the media and we've seen it with our own clients now, is that some employees are better off being unemployed than they are working. And obviously that creates problems and issues, and think about an essential workforce where you've got people who you are requiring to come to work, you need to come to work to provide an essential service, and there may be people who aren't working who are earning more than they are, and they're coming in. And we have clients who absolutely committed to doing the right thing, looking at maybe having some degree of incentive pay, other options like that for people who very courageously are coming in to provide that essential service. But that's a very tricky issue from an employee morale and an economic issue. Anyway, Dan, now you had a chance to crib, look at notes, study. Can you answer this? Whatever questions out there.
Well, the question that I'm looking at now is whether there's a law protecting employees who aren't receiving their full weekly earnings and haven't filed for partial unemployment because the system is so backed up. Is a business held responsible for not utilizing new programs in place to keep employees working and on full-time payroll? For example, commission sales employees. So
I would add to that restaurant staff. We've seen some recapturing of front of house staff to provide takeout services, but then get let done for the night after 2 hours worth of work, and so they're not unemployed, but they're averaging like 6 hours a week, and haven't been laid off.
Yeah. So I mean, the response is that there isn't anything specific that addresses those employees who are having trouble filing through the state system. And obviously the hope is that those glitches and problems get worked out and the state's able to get its act together to provide benefits when they're applicable. I don't believe that an employer would have any specific liability if they're in a position where they can't offer work or full-time work to employees because of current economic needs or a decline in demand for employee services. And therefore they're not able to keep employees on full-time payroll. The one area that people should just be sensitive about is that if an employer plans to get a loan, a small business loan through the CARES Act, and plans to apply or get forgiveness of those loans, there are provisions in the CARES Act that limit the ability to obtain forgiveness for the loans for payroll costs if the employee count has gone down and the employer is not in a position or hasn't fully employed the complement of employees that it had been. Those provisions are very, very technical, but it's certainly something that if a business is applying for a small business loan under the CARES Act, they want to keep in mind, because there is the potential ability to have a loan forgiven if it's used to pay payroll costs. And there's been you've been able to maintain employees. The good news is that if your employee count goes down, it's not like you lose the forgiveness entirely. There's just a pro rata reduction in the amount of forgiveness of the loan that you might be able to receive.
Okay, I put one last question in the everyone box that has come in, and just want to name it out loud. And this is a really great question, and one I haven't had to deal with yet, but I feel like I'm pretty close to having to deal with. What do we do with an employee whose partner has been kind of not tested but told to self-quarantine, and your employee is sharing a household with them and they're not symptomatic yet, your employee? When do you say don't come in or take time off, and how do you balance risk to your other employees and to doing what mandates say to not having the evidence you need to know?
So I'll start, Peter, and then if you want to chime in on it.
Sure.
Under the Families First Act, if the employee has been told to self-quarantine by the doctor because of the roommate situation or the partner situation, then they would be potentially eligible for paid sick leave and expanded FMLA benefits, because the language is very broad that any employee who has been advised by a health care provider to quarantine due to concerns related to COVID-19. So if there's somebody that's in the house that has issues, and as a result, an employee's healthcare provider is advising self-quarantine, then regardless of whether they're showing symptoms, there would be eligibility for the benefit.
That would require the oversight of your employee and their doctor to extend their note and recognition to their patient to ensure that anyone else in the household is also self-quarantining.
Well, I think, just to follow up on that, I think the issue there would be, if it needs to be a healthcare provider, it's not a self-declaration by the employee. So the employer would look at that number 2 on our poster and say, I would need that to be a recommendation from a healthcare provider, and the new regulations that I recall indicate that you can request the name of the healthcare provider in that instance to obtain that information. So it's not a self-declaration, but one that's guided by medical advice. But just as Dan said, it's related. It doesn't have to be your own symptoms.
But this person's employee would have to have a note noting their need to self-quarantine because they live with somebody who's been directed.
Yeah, I mean, I think the most practical thing would be if that person contacts either, it says a healthcare provider, so I'm not necessarily sure it's their healthcare provider, although I don't know sometimes whether a healthcare provider would provide something for someone who's not a patient. I'm not sure about that. But in that instance, I would have the employee contact their provider. And as we know, again, we don't have to go to visit the doctor's office any longer and seek, a note or something that would say, yeah, you should stay home too in those circumstances. And that would be sufficient.
Thank you. We're pretty much out of time. Is there any final words that either one of you two gentlemen would want to say? And I will note, we did encourage folks to register even if they couldn't attend, so that they could get the recorded webinar and all of the handy links that Hannah gives us. And so you guys are always really good about following up with folks, and we'll make sure they're signing up for your updates. But I know that some folks are looking forward to reviewing this afterwards. So
thank you. No, absolutely. Feel free. As I said, there's a lot of resources on our Brann and Isaacson website, and anybody who wants to get on our list, we're putting anybody. It's not just our clients, but anybody who has questions, issues. There's a lot of resources that we've got the ability to send out, and we've found that people have found them very helpful. I'm not sure they read them all, but they might read them when all of a sudden they may pertain to an issue. So
I think it's a case of coming back to something they remember seeing when it suddenly matters.
Yeah, absolutely.
Yeah.
So thank you for hosting this again.
Absolutely. I'm assuming there will be multiple opportunities in the coming weeks for us to reconnect as things. I think I'm particularly interested in the way implementation and rulemaking really changes what we do understand. There's a couple of areas as it relates to the EIDL and the PPP that we're already hearing some eligibility changes and some things there that are kind of in the rumored but unconfirmed category that I think we'll start to see some guidance around the gray areas that weren't clear in the way the language was rolled out. So looking forward to being in touch with both of you over the coming
weeks. Yeah, absolutely.
Thank you.
Thanks
to each of you who joined too. We appreciate your time.
Take care.
Bye.
Bye.
Thanks, Jessica.